We also have, Milt, on that idea of descendability, our next case that you have here dealing with the Marilyn Monroe's will.
Sure. This is Shaw Family Archives versus CMG Worldwide. In 1962, Marilyn Monroe died. In her will, she essentially transferred post-mortem rights of publicity to her acting coach, Lee Strasberg. And when he died in 1982, he left his estate to his wife, Anna Strasberg, and which included these post-mortem rights of publicity concerning Marilyn Monroe. Marilyn Monroe's photographer, Sam Shaw, who was in Indiana, he entered in some kind of agreement with Target. So there was a T-shirt sold in Target with Marilyn Monroe's picture on it. CMG and Marilyn Monroe LLC sued Sam Shaw in Indiana federal court, and Sam Shaw had already instituted a declaratory judgment action in the Southern District of New York concerning this very same controversy. The case was transferred to the Southern District of New York, and the court found the following. Only property actually owned by a testator at the time of her death can be devised by will, and at that time neither New York or California, or for that matter, Indiana, allowed the transfer of post-mortem rights of publicity. So the declaratory judgment action was granted in favor of Sam Shaw, the Marilyn Monroe's photographer. In addition, the court found, I guess, subsequently after I'm having trouble saying Marilyn Monroe, subsequently after her death, both Indiana and California passed statutes which allowed post-mortem rights, transfer of post-mortem rights of publicity. However, the individual had to be alive at the time the will was devised. In this case, Marilyn Monroe was not alive, and so although Marilyn Monroe LLC and CMG made that argument, the court did not find any merit to it because Marilyn Monroe was dead at the time. The statutes, Marilyn Monroe was dead at the time these new statutes were enacted. Okay.
Well, now, we've also had the Central District of California issued a similar ruling dealing with Marilyn Monroe's will. Both of these, the one that Milt is talking about in the California case, were in May. Both of these cases prompted state legislatures in each state, California and New York, to deal with the issue. New York has never had a descendable right of publicity, but there is currently legislation before the state legislature to make the right of publicity descendable. It's been tough to do here because the media is very strong here and lobbies against this to have as robust a right as possible to use celebrity images. On the other hand, California, the law there was just signed, the legislation just signed into law this week, just 2 or 3 days ago, and what that did there, Milt, it is addressing this very issue, Marilyn Monroe's will. It applies to celebrities who died before January 1, this is the new law in California, before January 1 of 1985, have a descendable right going back, it goes back 70 years from 1985. If you want to count back, that means that Marilyn Monroe, who died in '62, would fall under this new California legislation. So here we saw very quick work by the California legislature in response to the two Marilyn Monroe rulings.
Patty Duke's agent negotiated with the Manhattan Ensemble Theater for a deal under which Patty Duke would perform the role of Golda in Golda's Balcony. And at some point after the negotiations had concluded and Patty Duke had already been contacted directly by the Ensemble Theater to begin learning her lines, etc., the producers learned that Patty had had a heart condition and wrongly assumed that she would not be able to perform her role. And so the defendants instructed their attorney to divest themselves of Patty, which sounds rather mean. And the defendants, in fact, cast Valerie Harper in her place. So Patty didn't take that very well, and she filed a complaint alleging breach of an oral agreement, promissory estoppel, a violation of Section 51 of the New York Civil Rights Law, a breach of the implied covenant of good faith and fair dealing, unjust enrichment, and 2 counts of employment discrimination. The court held that although the defendants claimed that there was an unsigned draft agreement indicating an intent to be bound under contract only upon entering into a written agreement, the court refused to consider that evidence since it wasn't relied upon in the complaint, and this was a motion to dismiss. The court held that the alleged oral agreement could be enforceable absent any explicit statement that only a writing would be binding. And in the event that complete negotiation of all terms had occurred and/or in the face of part performance, there could have been an enforceable oral agreement, and Patty was entitled to go to trial on that issue, or at least get through discovery. Patty alleged sufficient facts to sustain a claim, and none of the facts she alleged subjected the alleged oral agreement to the statute of frauds as a matter of law, the court held. Patty also adequately alleged a claim for promissory estoppel, and although the defendants moved to dismiss Patty's claim under Section 51 of the New York Civil Rights Law, the court held that the use of her name in flyers and advertisements announcing her participation in the play did subject the defendants to a Section 51 claim, and the defendants' defense that they were actually only talking about a newsworthy event was rejected by the court. The court said the purpose of the defendant's use of her name was for a commercial purpose and not to announce a newsworthy event. The court did dismiss the claims for breach of implied covenant of good faith and fair dealing. They found those to be duplicative of the breach of contract action. And they dismissed the claim for unjust enrichment because she didn't allege facts in support of that claim that were different than her Section 51 acts. And they dismissed the employment discrimination claims because Patty failed to allege that there was discriminatory impact in New York. So that's
Now,
Patty Duke.
the Section 50 and 51 is New York right of publicity law, but it's technically called the privacy statute.
Right.